Hi, my name is Jamal Watson with Diverse Issues in Higher Education magazine, and welcome to this panel, Affirmative Action and the Supreme Court, Equal Opportunity at Stake. We are so fortunate today to have an outstanding panel joining us today, and let me introduce them to you. We have Carol R. Ashley, an attorney at law with Jackson Lewis PC. David Hinojosa, who is the Director of Education Opportunities Project with the Lawyers Committee for Civil Rights under law. And of course, Ted M. Shaw, who is Julius L. Chambers, Distinguished Professor of Law for the Center for Civil Rights at the University of North Carolina, Chapel Hill. And of course, many of us remember and have followed him from his courageous leadership at the NAACP Legal Defense Fund for so many years. Let me begin with the conversation, if we can. In the next few weeks, the U.S. Supreme Court will hear a challenge to race-conscious admission policies at the University of North Carolina and Harvard University. Could the rulings in these cases effectively lead to the end of affirmative action in higher education as we know it? And I want to start with David, if I can.
Well, absolutely. That's exactly what they're gunning for with these lawsuits. They want to ban race-conscious admissions or affirmative action in higher education all across the board. They have these two lawsuits. They have another lawsuit filed against UT Austin that states the same, and Yale. So they're not just content with suggesting that the race-conscious admissions programs at each of these universities violate strict scrutiny, the standard that the Supreme Court has already put in place, since Grutter, and even possible and suggested that same standard in the Bakke case. But perhaps what's even more important is if this court does strike down affirmative action, is the basis thereof, right? Are they going to come back and say, for example, well, the compelling interest in the educational benefits of diversity, we find that just can't be measured precisely. And so until someone can measure that precisely, we're going to throw it out. They might say that universities, after researching the thing, re-researching the issue of whether or not the universities have a First Amendment right in selecting their enrollment, as they said, both in Bakke and Grutter and Fisher. They might come back and say, well, you know what, that's not true, the way that we read the First Amendment. But what could also happen is that the court comes back and reaches as far as Students for Fair Admissions, the plaintiff in these cases, wants to go. And they could undercut the purpose of the Equal Protection Clause and say that the Equal Protection Clause itself requires colorblindness. That's an argument that they and their amici have been pushing. And that poses a threat, not just to affirmative action in higher education, but lots of other great, incredible racial equity work that is being done and that needs to be done.
Yeah, no, I appreciate that. Attorney Ashley?
I think the reality for many institutions, educational institutions, and beyond that, as David has just mentioned, is a concern that all of the good diversity and inclusion work that has been done to date and the amount more that is needed is threatened by this potential decision. And as we know, and especially in the last 3 years, that companies have begun to understand even more so what diversity means to their employees and not only in the work that they do with each other, but the work that they do globally and that with other companies, and that looking for diversity and inclusion really is a business asset now. And so you have this divergence if the court goes one direction, where schools, where universities are a place where this happens, right? You want to hire people who've been to universities that have been diverse, because then they come to your employ and they're able to function in a different way, a higher level, a more effective, more just a higher level of acumen. And so it's very disconcerting to know that the work you've been doing for all of these years, both in higher ed and outside, may be limited very soon.
Yeah, Yeah, well said. And I want to talk a little bit later about some of those, the impact really of diversity and equity as it relates to affirmative action. But first, go to Professor Shaw.
Well, first, let me say thank you for this opportunity to join you and be part of this panel. I am struck by the manner in which the discourse has shifted, and in many ways is shifting back toward the use of the terminology affirmative action, because affirmative action was all but killed by the Supreme Court in its Vaki decision in 1978. And what snatched some measure of victory from the jaws of defeat was diversity as a compelling state interest. There's a lot that can be said about the overlap and the difference between those two concepts and the terminology, but suffice it to say that diversity was a First Amendment-based interest that the court found in Vaki. Affirmative action historically was based in the 14th Amendment imperative to remedy and address the legacy of and continuing racial discrimination. Overlap, but not identical.
Absolutely. Well said. And it seems like, as you trace the history and talk about Baki, every couple of years we hear affirmative action kind of becoming almost sort of not a buzzword, but it just kind of resurfaces over and over again. And I was just curious, why is that? I mean, why does that continue to happen over the span as long as I can remember, that it kind of is a big issue, then it goes away, then it's a big issue. Is it all because of the linkages to the court or in these lawsuits that come down the pike, or can any of you talk to that issue at all? David?
Yeah, it's interesting, right? Because I remember back in the Fisher case, I was involved in that case when I was at the Mexican American Legal Defense and Educational Fund. And that's the case filed against the University of Texas at Austin, trying to undo their race conscious admissions program. And there were discussions, nationwide with civil rights organizations, universities, and others. And people would say, well, there were some talking points that were being distributed, and they said, well, let's use affirmative action. We need to reclaim affirmative action. I was in San Antonio, Texas at the time. Texas is in the South. Mm-hmm. And we were like, oh no, don't bring your California talking points over here. Your West Coast talking points aren't going to work here in the South. But I do think that, part of this resurgence of the effort to push back and reclaim affirmative action is because of the worldwide reckoning on racial injustice, that it was experienced in 2020. And then the onslaught of activity that has come from the extremist right to undo whatever progress and to prevent whatever progress that might be on the horizon. So, Carol had touched a little bit on this, about, how employers were starting to look back at themselves, and reflect on, what inequities, they had. Colleges, K-12 schools, all were doing this. And so it prevented that, avenue for it. But meanwhile, you do have these cases that talk about affirmative action in very negative ways. They gaslighting the issue, saying, oh yeah, they're getting bonus points. Oh, they're on separate tracks of admissions. And oh, they're holding biases against, these students, where there's not much of that in the record at all. But when they gaslight those issues, the media picks up on those issues. So to understand affirmative action in the context of today, yeah, it's not what our mothers and grandfathers, or maybe even some of us, had experienced back in the day. It is in the context of colleges, it's a holistic admissions plan, right? Where race is only considered as a plus factor, and among many other factors. So at the University of North Carolina, there's 40 factors that may be considered, over 40 factors that may be considered, including a person's first generation status, their income, their grades, their SAT scores, et cetera. And to suggest that, race needs to be wiped from that, I think especially, with a lot of the youth have come back and said, look, race is integral to my experiences. It's integral to my talents. I cannot fully demonstrate, and we have testimony from some of the clients in our cases, that they cannot fully demonstrate who they are and what their full talents are without representing their race and their racialized experiences. And I think within this concept of how, of how the concept of affirmative action has evolved over time, I think, it's still going to be at tension, but I do think that there is a strong resurgence from, the youth and from civil rights organizations and trying to reclaim it as a real positive thing.
Absolutely. Professor Ashman, you want to hop in?
I want to make 2 points about what David said. When you're talking about separating race from a student in the admission process, we think about immutable characteristics and race being one of those. So the idea that someone, a reader at a school, can divide me and say, well, her experience growing up in that city, in that place as an African-American person or a Black person is separate from me, is in my mind just something that colleges can't do, universities can't do, because it is inseparable. But I think the court may, they've certainly indicated that they believe that you can divide a person. And if you go back to the Seattle Picks case, which was dealing with K through 12, Justice Roberts famously, said, you should stop discriminating based on race by stopping discriminating based on race. And I always found that to be so hard to read. It's removing so much of the context of what we actually live in from day to day. It is just not true that I can walk into certain places and somebody does not see that I'm a Black woman. It's a woman, Black. It's not feasible. And there's some ideology behind it that there's just a disconnect. So I agree when we start talking about dividing students up and parsing students, that it's really quite impossible, or, I can't understand how it could be done. And going back to the terminology, whether it's affirmative action or whether it's diversity, equity, and inclusion, I'm from the Midwest, and, in the same way, David, using the term affirmative action sometimes was very difficult because people had a negative reaction. But when you started to talk about what you were trying to accomplish, what the goals were, people could hear that better, sometimes under diversity, equity, and inclusion. So I think that's geographical. I think that's sort of community-based, but I think the ultimate place is to just, is to make sure what everybody understands what you're talking about, whether it's a corporation, whether it's in a city, understanding what your terminology means. I'm not so sure it makes a difference at the end of the day whether we call it affirmative action or DEI, as long as everybody understands in that community what you're talking about, and that it's meaningful. It's not just some, you put it on the shelf, we want to aspire to this, but that you actually take steps to create an environment where students want to go there because it's diverse, or you want to have a campus that's diverse. One thing I do want to talk about and hope we come back to is to discuss universities' missions, colleges' missions, because I think that's really critical to what the Supreme Court is trying to do if they're trying to change literally what a hundreds-year-old mission might be for an institution. But hopefully we'll come back to that.
Yeah, I also wonder if we have to kind of reclaim the narrative in many ways, and also attach the outcomes to the discussion, right? So whether we're talking about diversity, equity, inclusion, or affirmative action, isn't the key to show specifically how DEI initiatives or affirmative action is moving the needle in a positive kind of direction? And I think that's the charge, right? For sure.
Well, and I think that's what many corporations have been doing of late, because they can connect the public image of not being diverse and understanding that's going to hurt their bottom line. right? And the way they do business, if they do it in a cloistered way, it's really going to affect the outcome, to your point. So I think we are seeing more discussion of outcome, even in the DEI context.
Yeah, I want to bring in Professor Shaw for your thoughts as well.
There's a great deal of value in the richness of the discussion that we've been having, though underscore what I believe to be an important distinction between the term affirmative action and diversity, and to point up how the Supreme Court, or at least some on the Supreme Court, are deeply confused about that issue themselves. Diversity was not a term in play until the Bakke decision, until Justice Powell's opinion in the Bakke case, which for years was under attack by conservatives as not having commanded 4 other votes. So that the conservatives argued that there were never 5 votes in support of diversity as a compelling state interest. That was laid to rest in Grutter, the Michigan law school case. But there was not any use of the term diversity in higher education, or in law at least, that I can think of and point to prior to the Bakke case. It was about affirmative action. It was about remedying the history of discrimination against Black and brown people. That's an important distinction. The reason why the confusion is important, even now, if you look to one of the Fisher arguments and an exchange between Justice Alito, who asked a question of the university's lawyer in that argument, why should the son or the daughter of a Black double professional family get the benefit of extra consideration? They're not affected by discrimination, they're privileged. And why should they be the beneficiaries of affirmative action? That's the question he was asking. My answer to that question would have been, look, with all due respect, the Supreme Court really all but killed affirmative action as a compelling interest in the Bakke case, and ultimately it was replaced by the diversity rationale. If that's the governing rationale for race-conscious admissions, the son or the daughter of a Black professional couple still brings something different to the university and to the experiences of the university community and classmates, et cetera. The notion of no longer needing to include race-conscious measures or pursue them is really a remedial notion. It's in race-conscious remedies that there has to be an end. If diversity is going to be a compelling state interest, it's going to continue to be a compelling state interest. The only question is whether or not it happens without any deliberate efforts. Maybe we'll get there, but we're not right now. There's a great deal of confusion, even in the Supreme Court, about those distinctions and differences and what the governing rationale is.
Yeah, no, that's well put. And since we're talking about terminology, I think it's really important to point out, because I remember the first introduction that I got to affirmative action as a college student was that someone accused affirmative action as being racial quotas, and it's different, right? Racial quotas and affirmative action are 2 very, very different things, correct, Professor Shaw?
Absolutely. And by the way, because we know from ever since the Bakke decision, it should have been clear that a quota system, the use of quotas, is the kiss of death legally. for designing race-conscious measures. The other thing I wanted to mention very quickly, we've been talking about and using the term, diversity and inclusion. That term itself, or equity and inclusion, those terms are not part of the legal discourse. Diversity is, but when we talk about a lot of what the DEI community talks about, not all of those terms have been embraced by the Supreme Court. Whether they should be is another.
No, that's a really good point. Attorney Ashley, let's get back, if we can, to the point that you raised, which was the mission of these institutions to advance, though, diversity and equity and inclusion. I know that's their mission. And I was wondering, again, how can we tie in their support for affirmative action to those? Can we talk a little bit about that issue?
Well, I think institutions are challenged. I mean, some schools, you go back to their missions and it talks about wanting to have diverse students, or they, over the course of years, have included that in their mission. And how you achieve that, if the Supreme Court's decision is what many anticipate it will be, is going to truly be a challenge on campus. And I would like to say what consequence that has. As somebody who went to an institution that was predominantly white at the university level, there are consequences when you are the only. There are consequences when you are, within a campus or or not a whole campus, but in a class. And I will even fast forward to my own daughter's experience, even with a school with a mission that wanted to be diverse at a predominantly white institution, the challenges that students face. It is truly traumatic sometimes to be on these campuses and be isolated. And when, as an admissions group, you cannot take that into consideration and build a campus where you have enough people, critical mass, to have different perspectives, it really affects your educational environment, it affects your social environments, and really, I don't want to be dismissive of how it actually can affect people's psyches and how they are feeling day to day, and has true consequences. So at some level, it's very frustrating to read some of the arguments, not only in the legal briefs, but also in media, where people don't have an appreciation for that because they've not had that experience. And it's really quite, there's a dichotomy. We talk about mental health and we talk about wanting to make sure that people are cared for. But then when you talk about where race enters at, people act as if there's no relationship. And I think it's very dangerous to view it that way. And I think that it's very hard on students.
Yeah. David?
I think it's especially important for universities, state flagships like UNC, right, that are seen, because they're there existing, of course, for beyond its own boundaries, but to serve, the students and citizens and residents of the state of North Carolina. And so they have a great mission, as part of their university. And now, how do they get there? How can they fulfill that mission? Well, they've looked at different racial neutral alternatives, from percentage plans, taking the top percent in their state, what that might look like, giving greater weight to socioeconomic status and the like. But none of those race neutral alternatives, not surprisingly, don't work about as well as race. And so the only reason why they're trying to use race conscious admissions is because race neutral alternatives aren't enabling them to be able to achieve their mission, or at least get on that path forward. When you look at the Supreme Court decisions that reflect upon a lot of universities' own missions, greater missions themselves, in creating pathways, for future leaders, making sure that those pathways are open to all people from all walks of life, knowing that we have incredible inequities still within our system, there has to be a mechanism that helps achieve that. And that's how and why universities like UNC, pursue race conscious admissions. This is, and what's even more important for UNC is their dreadful history in discrimination, exclusion, and white supremacy. I'm not gaslighting the issue. That's a fact, and that fact is in the record. We had a historian, submit a full report that was unrebutted on that terrible legacy. So for the greater part of, what was it, nearly 200 years of that institution's history, it was a history of exclusion and denial. It's only been for the last, Ted will probably disagree with me, but technically it might be for the last 30 or so years that they were, out of court oversight, or at least, the federal Department of Education's oversight into its own admissions program. But I think it's adamant that, these pathways remain open, because the benefits of diversity themselves, and we might get into that a little bit more, but when you think about, it's not just the research that says, yes, improving cross-racial relationships and cross-racial dialogue, enriching discussions, reducing tokenism and isolation, in the classrooms, and all these experiences that Carol mentioned, those are actually occurring still at UNC.
Yes.
Race-conscious admissions has helped alleviate some of that, but if you wipe race-conscious admissions, any progress is going to be wiped. We know that, declines in underrepresented students of color in California and Michigan and Washington State and Texas and all these places where it's been wiped, where it's been prevented by the courts, has led to substantial, declines. And so how can you have a university holding out itself as a university that's intended to be open for all the people in the University of North Carolina, at least theoretically, a university that recognizes the own inequities within its system? I mean, Lawyers Committee has a school finance case against the state of North Carolina because the great inequities, especially for students in at-risk circumstances in North Carolina, that used to be headed by the Julius Chambers Center at UNC. But how can you have those visibly open to people and then try to ignore the racial inequities? It's just beyond me, but that's how and why, this fight is so necessary. Affirmative action is not the silver bullet, right? It's not going to resolve all the inequities, but it's incredibly important given the history and legacy of this country's own denial of opportunity, equal opportunity for all.
There's been a debate, as you all know, that perhaps we should focus more on socioeconomic status instead of race. And Professor Shaw, I want to go to you. What's your thinking about that? Should we be more interested in class socioeconomics?
Look, I am all for universities making it part of their mission to admit students who come from socioeconomic backgrounds that are unprivileged, regardless of their race. That would include poor and working class white folks. Having said that, we didn't fight a civil war in this country over class. Some people think we should or should have, but we didn't. We didn't have this country's greatest demon, although maybe some people will argue that too, from even before its birth. Be anything other than race. Race has been this country's greatest demon, and racial inequality rooted in our history of discrimination and segregation against people of color remains its greatest challenge. And even though some argued that we had achieved a colorblind nirvana after the election of President Obama, it became clear not long after that, if it was never clear, that race and what happened after President Obama's time in office continued to be our greatest dilemma. And it was not in spite of the election of President Obama, but because of the election of President Obama. So the bottom line is this: if we pursue race-blind, class-conscious policies, given the demographics of this country, as they still are constructed in spite of all the change that is happening, we will see more white, working class, and poor people admitted, but there's no guarantee we're going to see or continue to see the numbers of Black and Brown students admitted as we've had under affirmative action / diversity practices and policies. And so I don't think it's a substitute, and it won't be a substitute. So I'm not opposed to those efforts, but they're not a substitute. If we're going to be about the business of guaranteeing that the doors of opportunities of Black and Brown students remain open, it makes no sense to gouge out our eyes in pursuit of so-called colorblindness. We should be allowed to do what we are trying to do collectively in this country to maintain opportunity and diversity.
Yeah, thank you. Attorney Ashley, I want to bring you in if you can respond to the same question.
Yeah, the socioeconomic piece, it not only is it not a replacement for the kinds of diversity you're trying to bring to a campus, the models show you that you can't, and they've been working on this and trying to look at the layers of how you can use the geo levels and try to come up with the same results, and they cannot get there, right? They haven't been able to model it, and I don't think that's going to be that's not going to change, right? I think there's some confusion in the public that maybe because socioeconomic plans have been used at a K through 12 level in some instances, that somehow transfers over to the collegiate level, and they're very, very different scenarios. And even at the K through 12 level, many would argue that they weren't successful at creating the kind of racial diversity you wanted in a school district. And so the notion that you can transfer, when you're looking at a local situation, like if you're looking at the city of Chicago, for instance, which actually does not really use a social economic plan, but you can divide the city up in ways around schools, and you can consider socioeconomic factors and who will be admitted into some of your best schools in a way that you cannot do nationally when you are a school that is pulling across a state or nationally. And so it isn't a replacement. And I think because, I think it's easier to talk about class, I'm the reverse of what Professor Saw has said. People don't want to talk about race because it's so painful and difficult. People want to talk about socioeconomic because it's so easy, right? If I work hard, I can get ahead. And that is the case in some instances, but not on a broad scale. And so I don't think socioeconomic is the answer, but I think schools are going to explore it if the court takes this turn. I don't want to say that people won't try to use it and layer it into their admissions, but it won't get you the same place. I don't think the data will say.
Jamal, if I may, very quickly, because I know we want to hear David on this point, but it occurs to me that it's important to say that the discourse about using class forces us to ask the question, are conservatives who are making that point really inviting and interested in pursuing a discussion about class inequality in this country? I don't think so. It's only using that discussion as a weapon against race conscious measures that issue comes up. So I don't think it's even an honest discourse, even if we know that we do need, in fact, to address class inequality in this country.
Yeah, no, that's important.
I'm sorry, David.
No, thanks, David.
Now, I'll just add, a couple of points. One is that, yeah, quantitatively, there's still a hell of a lot more poor white folk than there are Black and brown folk in America. So by the numbers, if you just looked at socioeconomic status, white students are still going to benefit more from that. And that's how and why they end up pushing, class-based. They don't really care about racial diversity, right? They just care about white opportunity. But then secondly, and sort of relatedly, is that when you look at a lot of the data, and SFFA's expert, Rick Collenberg, actually admitted this on the stand too, is that when you look at poor white students, they tend to go to better resource schools. They're still going to middle class, neighborhoods that are situated nearby. So they're going to better resource schools. And if they get better resource schools than a high poverty, high minority school, then of course, their resume is going to look better than, a person of color. And beyond, other issues that involve, racial biases and testing itself, we still have student testimony in the record. Again, it's not just, in the research, but about students whose own counselors were gatekeeping advanced courses from them. It wasn't because they were poor. It was because they were Black or brown and didn't think, because their own biases against them, they didn't think that they could succeed. They didn't think that they were college material. And we have one student who's now in medical school. He didn't have, super high test scores or anything, but he fought to be admitted to some of those college preparatory courses. Many of the white students who had, taken many more courses, went to UNC with him and enrolled in the pre-med program and dropped out, during that first year. Well, he's, pursued, and that's the kind of opportunity, make sure that students who are typically overlooked, if you look at what the race neutral metrics are, because those race neutral metrics, again, those definitely still tend to benefit more privileged people, right? GPAs are influenced by advanced coursework. Well, you're going to have a higher GPA if you take more courses if you have more courses that are international baccalaureate or advanced placement or the like, and if you have access to those. So what kinds of schools have more of those opportunities? It's the schools that many Black and brown people don't. The last two more points that I do want to add there is that it ignores the importance of intraracial diversity. As one of our clients, testified, Blackness is not a monolith. And going to a university and you see people coming from different classes, different experiences, really lends to, the openness and the richness of the discussions themselves within the classrooms, which again, is one of the aims for universities, is to build those rich discussions going on in the classes. But lastly, and this was already touched upon by people, but we had students testify in the case that said, people weren't hurling racial slurs at me because I was poor. One of our clients talked about, people going by in a truck and honking the horn at them and yelling at their family as they were just driving down the street on a day, yelling out, "Hey, aliens, go back to your country." Don't know anything about that family, and spitting it out at their car door, and the kid looking at his parents like, what's going on here? Other people who were kept out of parties at UNC because they said, oh, we don't let the descendants of slaves here. You know, someone who was middle to upper class, you know, going to that place with their friends and being told that, you know, having to walk across campus, seeing, you know, these monuments and these buildings named after, you know, white supremacists, as one of our clients referred to as the racist graffiti. That doesn't impact someone because of class. That's race playing a role. And so again, you know, it's definitely an and issue. So yes, socioeconomic status should be a factor in consideration, but it's not an either or. And it's certainly not a substitute, as Carol and Ted have shared.
Yeah, David, the group Students for Fair Admissions, as you know, has argued that diversity as a compelling interest has, quote, no true defenders, because the real supporters of affirmative action really only support it as a tool for remedying past societal discriminations. But the court have rejected affirmative action as a remedy to societal discrimination. What do you say in response? And how does such a contention comport with the several dozen amicus briefs that have been filed in support of diversity?
So it is highly unfortunate, you know, that the court, it is highly unfortunate that the court has rejected affirmative action as a tool for remedying societal discrimination. You know, they claim, you know, the theory is, well, they don't want to punish individuals who took no part in the past discrimination, but this ignores, you know, generational impacts of societal discrimination on people of color, especially Black people in America, where because of their race, they were wholly denied opportunities. Not just them, you know, their grandparents and their great-grandparents and so on and so forth. And so that systemic denial of opportunity and that systemic subjection to discrimination and to slavery, right? You know, slavery is a form of discrimination, but certainly, you know, at such a magnitude. And to sort of ignore that and say, well, you know, this person right here in front of us still didn't participate in that. And to suggest that they don't have those opportunities, or, you know, maybe, you know, didn't necessarily benefit directly from those privileges, you know, ignores the larger point. But SFFA, you know, has tried to gaslight that issue to suggesting that, you know, diversity has no true defenders. And, you know, Ted's right, you know, maybe diversity wasn't, you know, so prominent as an interest of universities, you know, directly in the 1970s. And that's because they had access to affirmative action itself before the Bakke decision in 1978. But Harvard was one of the leaders in this area, you know, identifying what, you know, some of these educational benefits of diversity might be, and many universities followed suit. And so today, you still can have detractors from, you know, those who fully support diversity, but there's also wide support on this. And for them to suggest that there's no true defenders, they can look at 58 briefs filed from multi-sector stakeholders in this case. This includes this association, this great association in itself. It includes universities, public, private, religious groups, military leaders, employers, medical associations, psychologists association, bar associations, so many civil rights groups along language, ethnicity, including Asian American civil rights organizations as well, and social scientists. You know, you look at the broad spectrum, and to suggest that diversity has no true defenders or supporters, it's just flatly wrong, and it belies the record. Are there still certain detractors? Yes, you know, for good reasons, yes. But when you look at their amicus briefs, and they had roughly, I think, 34 amicus briefs filed in the UNC case, at least on their side, they're mostly from these far-right think tanks. You know, they're not from student organizations, they're not from universities, they're not from employers. You know, so again, you know, if you say that there's no true defenders, that's just a flat out lie.
Yeah. Attorney Ashley, you want to hop in there?
Yeah, I mean, I think David hit all the points there. I think there are narratives that people want to make or are made in briefs that are not consistent with the facts. And I will add, when we talk about race conscious remedies, I think it's really important to understand, you don't get into a school because you are this race. It is, you can do the work, right? You've met the standard that you can do the work. And then there are other factors that are considered, and it's a complex web. If you've ever dealt with admissions in a college or university setting, it is complex. It is not a simple process. And I don't want people to believe that somehow some group of students who cannot do the work are being admitted into schools under these rubrics. That is not the case at all. And you can talk to many folks who did not get into institutions, because of whatever their standards were. So I think the narratives are important. We want to make clear that people understand that you're considered as a whole student. I think David said at the very beginning, this is about holistic admissions. And sometimes when slices are sort of thrown out there, it's convenient. It sounds perhaps good to a certain audience who may not have all the information, but it's not consistent with the record.
Yeah. Professor Shaw, you want to add anything?
I was in the Supreme Court when Bakke was decided, when it was announced in June 28, 1970. And I will never forget, talk about this probably in minds of some ad nauseum, but I will never forget leaving the court that day, devastated because Bakke was a loss for African Americans in many ways, including some of which we talked about. David is right about how unfortunate it is that the court said what it said about so-called societal discrimination. Here's a point on that. When conservatives lose in arguments they make and in cases they bring to the court, as they did in Roe, they don't give up and go away. They fought for decades and decades, over 4 decades, before they won, almost 5 decades, before they won a reversal finally of Roe. There were a lot of things about Justice Powell's opinion, including the societal discrimination piece, but also the cramped interpretation of the 14th Amendment, the court's deliberate ignoring of the legislative history of the 14th Amendment, which makes clear, or should make clear, that race-conscious measures are not per se racism or violation of the 14th Amendment. All those things and more were wrong. And we should have been engaged in a long battle, just as conservatives were, to overturn Roe, to overturn the incorrect interpretations of the 14th Amendment and applications. My point is this, that there is still a lot of work for people who believe in our vision of the Constitution to do. And just because we have these 2 cases before the Supreme Court this term, before the most conservative court that any of us has seen in our lifetime, doesn't mean that we should despair or give up. We can't do that. Whatever comes out of these 2 cases, and I know that it doesn't look good, diversity has become a worldwide value that has been accepted around the globe. And it will, in one form or another, survive whatever this court does, because it has become a value that is accepted and implemented in every corner of society.
Yeah, no, well said. I can't help but think about the impact of George Floyd death and the aftermath of that. And we, of course, saw so many institutions putting out statements and companies pledging support for diversity. I was just curious what that movement might mean for the affirmative action movement, if possible, in terms of, again, we see the mass mobilization of an interracial group of young people rallying around these kinds of issues relating to diversity as well. And I was wondering if any of you had any thoughts about that.
There's definitely, a relationship between, the two. We've discussed that some here today. But I will say that the other side knows the connection between this. The other side knows that, it started with Trump's executive order 13950, right? To try and eliminate conversations and trainings, incredibly important trainings on implicit and explicit bias and the like, critical conversations in federal agencies that needed to take place, right? And so he instituted that EO 13950 to try and stop those. That, was subsequently enjoined in part, by California District Court, but it was also removed by President Biden, thankfully, on his first day of office, removed that executive order 13950. But that whole movement has now generated a nationwide movement by the other side to attack K-12 curriculum, to attack universities and their own, teachings. It's this whole anti-truth campaign where they want to eliminate discussions about past discrimination, about discussions about the present day effects of that past discrimination on continuing inequities. We have a lawsuit against Oklahoma, and I don't want to get too off part, but in Oklahoma, this public school district provided training on diversity, equity, and inclusion, and included demographics on the disproportionality of school discipline. They said that violates their law that was based on EO 13950. Oklahoma passed HB 1775 that is based on it. This whole attack on diversity in the courts and the affirmative action cases is also undergoing an attack in many states. There's 17 states, approximately 17 states that have passed laws based on Executive Order 13950, and they definitely see that relationship. I know that we are working on helping to convene youth and alumni very soon to try and get some energy going on the other side to try and push forward for racial equity. Who doesn't or who shouldn't believe in the incredible benefits of racial equity? And again, it's something that requires significant resources. We're working with many other allies in this space, but it's definitely something that is needed, and the connection is seen there by many of us working directly on this, but how much of that information is bleeded down into the general public, I'm not too sure that we've been that successful.
There are so many institutions that have adopted, and I take Professor Shaw's distinction, to heart in terms of diversity being a legal concept, but then the inclusion and equity being part of the social concept or business concept. So many places, institutions already have these kinds of programs operating. And what they should, in my view, be doing right now is making sure that they can continue to do as much of that work as possible, because the need has not gone away. The past 3 years I don't think I was ever under any impression that there are dangerous situations for me because of my skin color, right? That shouldn't be dangerous situations. I don't think I was ever not under that belief system. But for people who have come along to that and said how difficult, like how horrifying that is, right? To see somebody treated in a way that they may lose their life, or they do lose their life because of the color of their skin. And in most people's views, if you look at some of this footage, you cannot tell an organization, stop talking about how race works in your institution, right? Because we're at a different place. And I will say one thing that I really appreciate. I think the newer, younger generations are less tolerant of discrimination in the employee setting. I think that they are filing more charges if they see something that they don't think is right, if it happened to them, if it happened to somebody else. And I think that is a separate business reason why institutions, even educational institutions, have to think about how they train on issues of race and how they incorporate all of their community, how they recruit and how they retain people. So whatever happens at the Supreme Court, that doesn't change, right? And so people have to figure out as much of that as they can to continue the work because it's so critical.
Yeah, no, well said. We're almost out of time. I just have time for one last question, and that is, as the nation awaits for the court to rule on affirmative action, I'm just curious, is there anything that the Biden administration, Congress can do to weigh in on this issue to protect affirmative action, Professor Shaw?
Well, the Biden administration is already weighing in, at least in these two cases. And as David indicated, and as usually is the case, the Solicitor General of the United States Department of Justice will argue in support of diversity efforts in the arguments on, we haven't mentioned it, but it's October 31st. You can draw your own conclusions. But the Justice Department, fortunately, because this is the administration it wouldn't have happened during the prior administration, did weigh in the right way. There are other things that can be done to quietly prepare for an adverse decision if one comes down. And that includes working with individuals and organizations and groups and civil rights lawyers to draw plans and practices that once we see what the court's decision says, charts the best course possible that avoids, as much as is possible, painting a target on institutions' backs. We've seen that happen before. There has to be a lot of collaboration and planning that anticipates, but also that follows whatever comes out in this decision, and the federal government can play a role.
We are out of time, and I want to thank all of our panelists for such great insight. I certainly learned so much today. Thank you, Carol. Thank you, David. Thank you, Ted. And look forward to continuing this conversation down the road. Thank you.
Thank you for having me.